Kanu said, "Major reasons why Nigeria courts can't try me." You're welcome to this news. Please do well to listen to the end. Ñnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, has urged the Federal High Court to decline its jurisdiction to adjudicate over the alleged charge of treasonable felony filed against him by the federal government. The secessionist agitator pleaded not guilty to the 7-count amended charges against him. He noted that from the 7-count amended charge, the only element requisite to constitute and found liability for incitement allegedly occurred wholly and entirely in London, United Kingdom, and not anywhere within Nigeria. In his notice of preliminary objections filed against him, he argued that the alleged broadcasts were not shown to have occurred at sea or on the international waters abutting Nigeria, adding that I know as a fact that London, United Kingdom, is a sovereign state under international municipal law and has municipal laws punishing criminal offences. The preliminary objections filed by counsel to Kanu, Ifeanyi Ejiofor, further stated that I also know as a fact that jurisdiction is intrinsic to adjudication. It is conferred on a court. Allured, it is not intrinsic. That I know as a matter of fact that as the elements necessary to constitute incitement in the alleged several broadcasts of the defendant or applicant occurred in London, United Kingdom, and not in Nigeria. The court in Nigeria has no jurisdiction to try the defendant or applicant on any charge founded on any such alleged incitement, even if the defendant or applicant enters within the geographical boundaries of Nigeria. The affidavit in support, deposed to by Chinwe Umeche, equally averred that I know as a matter of fact that the alleged offences for which the defendant was charged do not constitute terrorism offences in London, United Kingdom, where they were allegedly committed. That I am further aware that there is an obligation on the Attorney General of the Federation to maintain international cooperation for compliance with international treaties on terrorism. That the defendant was abducted from Kenya and consequently extraordinarily rendered to Nigeria without firstly subjecting him to extradition proceedings in Kenya. I know as a fact that this is a violation of all known international conventions and treaties on extradition. That prosecuting the defendant on the 7-count amended would amount to following the complaint to benefit from their illegality and wrongdoing. That I am aware that he who comes to equity must come with clean ends, and no party should be allowed to benefit from his wrongdoings. That I know, as a matter of fact, that the extraordinary rendition of the defendant robs the Honourable Court of the requisite jurisdiction of trying the defendant on counts 4, 5, 6, and 7 of the amended charge. That counts 1, 2, and 3 of the amended charge were brought under a non-existent law. That count 3 of the amended charge relates to an offence allegedly committed in Ubulusuzo in Iliala local government area of Anambra, which is outside the territorial jurisdiction of the Honourable Court. That I know, as a matter of fact, that an offence can only be tried by a court exercising jurisdiction over the place or area where the alleged offence was committed. That counts 5, 6, and 7 of the amended charge do not disclose an offence known to law. That there is no proof of evidence attached to the amended charge filed against the defendant. That even the purported proof of evidence to be relied upon by the prosecution does not disclose any prima facie case against the defendant. That from the list of exhibits and witnesses attached to the amended charge, there is nothing relating to or linking defendants to the 7-count charge, particularly count 4, 5, 6, and 7 of thereof, that no final pronouncement has been made on the purported proscription of the indigenous people of Biafra, as the said purported proscription is a subject matter of appeal in appeal number CA/A/214/2018, pending before the Abuja Division of the Court of Appeal, that the defendant or applicant cannot be arraigned anew or tried for an offence when the judgment that made a pronouncement on the instrument constituting a state of affairs as such an offence is the subject matter of an appeal, that it will be most unjust, painful, wicked, and unfair for the applicant to undergo the rigors of a full trial when the amended charge as constituted does not disclose a prima facie case against him, that there is no ground for this honourable court to proceed with the trial against the applicant in the circumstance of this case, that the court has no power and a duty to stop a prosecution which on the facts creates abuse and injustice, that it will be in the best interest of justice if the present 7-count amended charge is struck out and or dismissed. Ñnamdi Kanu is saying he listed out the major reasons why Nigeria courts can't try him. It was in Kenya when he was extradited back to Nigeria. All the charges that was allegedly against him was not done in Nigeria. Most of them occurred in London, United Kingdom, and not anywhere within Nigeria. The 7-count amended charge is the only element precisely to constitute and found liability for incitement allegedly occurred only and entirely in London, United Kingdom, and not anywhere within Nigeria. Ñnamdi Kanu, via his counsel, who is Ifeanyi Ejiafo, stated that he knows as a fact that jurisdiction is extrinsic to adjudication, that he knows as a fact that has the elements necessary to constitute incitement in the alleged several broadcasts of the defendant or applicant occurred in London, United Kingdom, and not in Nigeria. The court in Nigeria has no jurisdiction to try Ñnamdi Kanu on any charge founded on any such alleged incitement, even if the defendant enters within the geographical boundaries of Nigeria. All the crimes that he was alleged of did not happen in Nigeria. So the court in Nigeria has no right to bring him or does not have any jurisdiction to try him. We have come to the end of this news. Thank you for listening, and God bless you all.